Good morning, everybody. It is Tuesday. It's 10 o'clock Central. It's time for our weekly Nomberg Law Live. And what I like to say each week is I have interesting conversations with people in their areas of expertise. And I'm not going to call her an adversary or a someone who David and I butt heads with, but in fact, it's someone who we've now befriended over the years. She is Tracey Stallings, and she's part of the work comp equation that if you guys know us, know our firm, that's what we do. But what we're going to do today is talk a little bit about that equation that most people don't really know about. So I guess my first order of business would be to say good morning, Tracey. Thank you for appearing on our show today.
Thank you. Thank you for inviting me.
Absolutely. David and I have dealt with Tracey for many years. She is a real pro, a real veteran in the workers' comp insurance side of the equations. So let me set the stage, and then I'm going to let Tracey kind of talk a little bit from her perspective. You have an injured worker. The injured worker will contact the law firm. The lawyer will then write a letter of representation. And that's typically what a letter of representation is. It's the way to let the insurance company, to let the employer, to whoever's needs to know our firm now represents the injured worker's interests for a workers' comp or some other type of legal matter. So typically my letter is going to end up on Tracey's desk. Tracey, here's where you come in. Explain your side of the equation, and then we'll just get started here.
Most of the time in a letter of rep, almost every single attorney is going to ask me for the same thing. They're going to want a copy of the first report. Mm-hmm. They're going to want a copy of the wage statement. And I go ahead and give those. Respond quickly and friendly. And, hey, here's what's going on. Here's our current status. And is there anything that he's questioning? Is your client upset about something? Is there something I need to be fixing? Did he not feel like he was in a loop of some sort? Some communication breakdown? Is an issue with us, with the employer? Because a lot of times they're going to go to the attorney because they feel like they've had an issue. So I want to make sure right off the very beginning that I respond to your letter quickly and that any communication breakdown is immediately fixed. And go ahead and get you that first report, go ahead and get you that wage statement so that we're all immediately on the same page and everybody knows what's going on.
And you brought up a great point that I missed, is the reason why the injured worker typically is going to contact an attorney is because they feel something is not being done. Something is wrong in this equation. Their medical care is not being paid for. They're not receiving their workers' comp checks. Maybe the claim is still under investigation or being denied for some reason. So they want answers, and that's why they've come to the law firm. And that, as I've said for many, many years, my job is to help get those answers. It may be that it is an area of the law that I know and I can explain, or it may be where we need to get in touch with Tracey or someone similar who represents the insurance side of this equation to help work through the issue, whatever it is. Now, inevitably, I'm going to take the position, if I have agreed to take on the case, that my client is deserving of X, Y, and Z rights to be protected, whether it's medical care, whether it's compensation because they're not working, whatever it may be. Tracey's job is to make sure that I'm right or that I'm wrong. And sometimes, quite often, actually, that's where we end up butting heads. And that's where I want to take this, Tracey. This is what I want to talk about a little bit. In our world, or let me ask you, in your world, what percentage would you say, if you can quantify this, of cases that come across your desk that actually end up in a court of law, meaning a lawsuit has been filed? And the reason why I ask, on our side of things, very small percentage, 10%, maybe 15% if we're feeling particularly mean that day or something, but no, a very small percentage of our cases are a filed lawsuit, typically in the county where the accident or injury has occurred, which means 90%, 85 to 90% of our cases get worked out through communications, typically with an insurance claims representative. So I'll stop talking, Tracey. I want you to kind of share a little bit of your experience. Do you have a higher percentage of cases or a lower percentage that end up into court?
I would say on average 10 to 15%. My caseload particularly is a little more skewed than that. I tend to handle what we call catastrophic cases, which are your brain injuries, paraplegics, quadriplegics, and your extremely severe injuries, burns, stuff of that nature. And a lot of times those involve a lot of more multiple parties. I also get a lot of the subrogation cases and stuff of that nature. So I have closer to about a 25%, but even then, most of those are not going to go to a court.
Yeah.
And normally only if there's a lack of communication or just too many parties and too many complex issues that are to be decided. For the most part, I'm with you. Everything can be communicated. There's very little that happens in workers' comp that can't be worked out and discussed in some way. If we're concerned about doctor's appointments, maybe you're concerned about time issues. And as long as that communication is open, you'll find out that most of the time those are non-issues. It's something that was a simple misunderstanding, simple confusion, not knowing how something is supposed to work. A lot of patients, they get frustrated because maybe they want to go to their personal physician. Workers' comp doesn't do that.
Yeah.
And that's a statute. That's not us. That's not our decision. It's not the employer's decision. It's not their decision. And I think for a lot of people, that's out of their comfort zone. And I get that. And they get confused and they get upset that it doesn't work like they think it should work. And they need somebody to make sure that they're being told and doing the right thing.
And I think that's where we come in. I truly find that my job and our firm's job and responsibility, that once a new client signs a letter, or a contract to hire us, my job is to provide answers. We have all kind of social media that provides that. We make sure that we have a 24-hour return phone call rule, those kind of things, because nothing stresses out someone who's injured more than not knowing what's next or what to expect, because all of life's stresses ramp way up when they get hurt. Because if you think about the equation here, when somebody gets hurt on the job, not only is their health impacted, but their ability to work, which impacts their ability to earn. And so the lifestyle they have been accustomed to based on their income, that's impacted, which in turn means that communication within the household is impacted. So it's just a snowball effect. So going back to the topic of litigation, Tracey, what would you say are typically, you mentioned communication, because I bet that's the overall umbrella answer. What are those topics? What are those things that you see typically lead to lawsuits, whether it's a lawyer representing them, or sometimes you'll have a pro se situation where the injured person represents themselves? But what kind of topics, what kind of subjects typically lend themselves to getting into court?
I'm going to say one thing about the pro se thing. If any client's ever looking at doing something pro se, I have a pre-law degree. I have a paralegal certification. I started off as paralegal. I say this with understanding. Please never do that. It is not going to save you. And the legal system is extremely complicated. You're going to need access to stuff like Westlaw and being able to look up court cases, because the law may say one thing, but court cases may have modified that. So I'm just going to say, if you ever go pro se, really, really double think that.
And as David likes to say, please don't let Google be a substitute for my law degree.
No, it should not be a medical degree or a law degree.
That's right.
I think a lot of some of our confusion comes in because people get confused about what workers' comp. Well, my friend did so and so. Well, your friend lives in California.
That's right.
what a lot of people don't know is every single state has a different workers' comp.
Mhm.
Workers' comp is not a federal law. It is a state law. We have a 3-day waiting period.
Mhm.
One state's going to have 14, another state has 7. Some of them don't have any waiting periods. Some of them pay 60%, some pay 66%. They're not the same. Even if you are in Gulf Shores and you're a friend in Biloxi, you're going to have 2 different workers' comps.
And Alabama is the only state that's litigation based. All the other states have administrative based or councils or panels. It's way different than it is in Alabama. But getting into court, I'm going to assume if you have a denied claim, but the injured worker thinks that it should be an accepted claim, whatever the reason may be, that can be an argument to get you into court.
Mhm.
Not providing medical care as the injured worker thinks, maybe through a panel of 4, that's a second opinion, or some other medical issue. What other things do you see?
There's basically 2 reasons you would see medical disputes or legal disputes. Medical disputes are maybe the doctors deem that it's not work related. Maybe they had an underlying personal condition. One of the things I use to explain it to people is just because it happened at work doesn't mean it's work related.
Oh yeah.
But they feel like it should be. Alabama case law has said that strokes and heart attacks are typically, I'm not going to say never, typically not covered. Well, somebody's going to feel it is. Alabama also says there's no psych care for stress only. It has to have physical components to it.
No.
And we're in a time where we see some tragedies at work, but we can't cover a PTSD kind of thing for somebody that wasn't involved. And I hate to use this as an example, but we had a local company that had a parking lot shooting, and a couple of the employees were traumatized. I get that, but we couldn't help with that. But a lot of times they won't understand that, and so you'll see those kind of things come up in court. Denials have to be very specific. They have to be based on specific criteria. Well, there's going to be a lot of he said kind of disputes there. So sometimes we'll wind up in court if only to do depositions and get some kind of testimony on the record so that maybe we can go to a mediation kind of aspect and communicate and come to some kind of compromise. So that's a couple of legal and medical reasons. Doctor has said something or the attorney has said something, because a lot of what we do, we're going to be basing it on a defense attorney because we are not doctors and we are not lawyers. So normally everything that we do is going to be based on some specialist information of some type. And you're going to have people that are just going to disagree. There may be a dispute on what wages to pay. Well, normally I made so-and-so, but during COVID, my salary dropped way low. So I think I should be owed more. Well, again, the workers' comp statute is very, very, very specific that it's based on the last 52 weeks. But we might still have a dispute over that. So basically, most of the disputes are going to come down to trying to find that compromise, trying to find what the actual documents are, what the documentation is, what's set in stone, what's not set in stone, and then be able to work through that.
Yeah, going back to the stress aspect of this, I'm sure you deal with this just like we do. Once the injured worker takes a little bit of the emotion out of the equation, and that's very hard sometimes because, as I said earlier, all of those life stresses have ramped up. But once you can get an injured worker to understand how the law operates and how the work comp system is designed, what it is designed to do and what it's not designed to do, sometimes that still makes it very difficult pill to swallow. Like you said, well, my cousin in Florida or my friend in Georgia or wherever it may be, you can't do those comparisons. So here's my question for you, Tracey. If you've got a situation where there's not a lawyer representing the injured worker, you guys are dealing directly with the injured worker, how do you continue to have those types of conversations that don't blow up? And I know they do at time to time, but how do you deal with that? Because I know that we have, and as long as we've been doing this kind of work, sometimes we have an extremely difficult time and have to separate our representation. We have to terminate sometimes if we just can't, I guess, not prove, but be able to get to that person to show them how all this works. I guess my question to you is, how do you deal with those difficult situations without it escalating to more?
A lot of empathy, a lot of patience, and trying to remember that they just don't know.
Yeah.
I've had 20 years
Mhm.
to figure out some of these nuances and some of these very specific minor things, major things,
Mhm.
and they don't. They were doing their job. They have been in manufacturing. They've never done anything like this. They've never had another workers' comp claim. And a lot of it is just like you have to kind of get some kind of rapport, at least some kind of, I understand. Let me explain. This is what we're limited to. This is what we can do within this framework. Yeah, I understand your frustration. I understand that you feel like you're kind of lost, but we have ways around this. And I'll be honest, there's some that they don't want to believe me. And I get that. This is not derogatory toward any person, but we've all kind of grown up, especially in Alabama, we kind of have a mistrust of big insurance companies, corporations, and they don't know that I'm in a small insurance company with 8 adjusters. We are not a large nationwide company. We are local. We're in Alabama, and we're in Montgomery, and we are not some big bad insurance company. But they don't know that. They know what they've seen on TV shows. They know what they've seen on Law and Order. And sometimes I have to kind of break through and go, okay, here's what you can do. You can call the Alabama State, the Department of Non-Industrial Relations. I just aged myself right there.
Yeah.
Department of Labor, Workers' Comp Division, and there are ombudsmen there that can help you. Mm-hmm. Make sure that talk to them, and then I'm telling you the right thing.
Mm-hmm.
And a lot of times they'll call back and go, okay, we've kind of made a trust. They now know I'm not lying to them, and that kind of thing might break through. Or I've even told them, sometimes I've had to flat out tell them, why don't you call a plaintiff attorney and see if they can explain it? Mm-hmm. Because there are times that it's actually more helpful if they come and talk to you.
Well, I was just getting ready to say, sometimes when we're able to express things that they've already heard from you, but now they're hearing it from me, and you and I haven't talked or even know that you're on the other side of the equation here, but they're hearing it from another person of experience. Sometimes that sinks in. Now, that doesn't necessarily mean they're automatically going to hire my firm to represent them. That's why we have our YouTube channel out there with all the videos. That's why we have a website. We have all this free information so you can start educating yourself. But I want to ask you this, Tracey, how often would you say you're able to resolve a particular claim or claims, and you never need or never have a plaintiff's attorney? The injured worker is not represented, they're pro se. I suspect that's a pretty good percentage of the time, at least historically. I don't know if COVID has changed anything.
Not really.
But I was going to say, but don't you have a certain percentage of your cases, your claims, where you're able to resolve the claim with the injured worker directly, and you never have to have counsel involved?
The vast majority. I would at least 75%, at least. And I would say, and just to clarify earlier, I've maybe said go to a plaintiff attorney like 5 times in 15 years. It's not a frequent thing, but at some point it might reach that level of conflict.
Yeah.
And if you're not going to be able to communicate with that patient, because sometimes they're just mad at the world. They're mad that they got hurt. They're mad at themselves. They're mad at their families for not being able to care for them.
Mhm.
They're mad at the situation. And sometimes you're just not going to be able to break through to that. So please don't think that it's like a common thing that I do. But there are times that, sometimes you need to be willing to kind of think out of that box and to keep all your aspects open.
Yeah.
But as far as the vast majority, most people are very cordial. Despite the fact that you hear of a lot of fraud, there's not a lot of fraud on either side.
Yeah.
Most adjusters, we're not here to make things harder. Our job is to make things smoother. And it does not benefit us in any way to make it harder for anybody. Us, you, patient, no, the employer, nobody. It doesn't benefit anyone for that. So nobody's trying to squirm out of things. We don't see a lot of fraud from employees. We see the occasional, but it's not, I would say it's less than 5%. And that works both ways. So for the vast majority of people, it's going to be very cordial. It's going to be very beneficial. They're going to call and go, hey, I was just asked a quick question. Okay, what's up? Okay, thanks. Hey, I lost my script. What do I need to do? Well, I'll call the doctor and have him get you a new one. Or we'll go ahead and get him to call it into, Walmart, pharmacy, CVS, whatever. There's always a solution.
But it may not be the one that
works.
the injured worker wants.
No, and it may not be the one that I want or an employer wants or the doctor wants.
Yeah.
And a lot of times we might have issues getting a patient in. For instance, right now we have 3 to 4 neurologists in the entire state that will even accept workers' comp.
Well, you're headed to my next topic with that, but go ahead with that thought.
So I might call you back and go, well, the first appointment we can get you is January the 28th.
Right.
Well, they're in pain. They want that appointment now, but I cannot make it happen.
Yeah.
So there's just some things that is just not possible.
Guys, I'm talking with Tracey Stallings. She is a veteran of the workers' comp equation, representing insurance companies in claims where injured workers are making work comp claims because they are claiming they've been hurt on the job. And we're talking about communication, because that's the key to, really anything in life. But with the Alabama workers' comp system is set up, while it is adversarial in nature, it can end up in front of a circuit court judge for a trial. A great majority of the situations claims end up in some type of compromised settlements, either through formal mediation with a neutral third party or informal, just discussions between the parties. And that's really where I'm headed with this. I read a statistic from a few years ago. On average, there's between 17,000 claims each year in the state of Alabama. I don't know the current stats, the post-COVID stats, but of those 16 or 17,000, I suspect only a few hundred of those end up in litigation. So the great majority of them work their way through the system in an informal way, just with the insurance claims department or whatever they're called at that particular company, with or without an attorney, and they just resolve themselves however that they should, whether it's with medical care or maybe it's a situation there was no medical care. My point being is communication between all of the parties is going to be the key for any of this to be resolved without being so adversarial. Sometimes you can't help it. Sometimes they're just the parties see things differently and they need somebody to resolve it. But I will say, during COVID, and this is my question to you, Tracey, during COVID, yes, the numbers of injuries or claims dramatically was reduced for the obvious reason. But now that we're getting a little more used to this during the pandemic and people are getting their vaccinations and getting back into the workforce and businesses opening, those claims, this is my question, are they on the rise? Have you seen that in the last, say, 6 months to a year?
Yes. We did not have a dramatic drop because of the the kind of insurance that or the kind of accounts that we write,
Mhm.
but there was a drop. But overall, we're already seeing the increase, especially as the unemployment's coming back and lowering down. People are starting to bring back.
Right.
We're starting to Alabama has a lot of manufacturing. I don't think people realize just how much we do.
Yeah.
Hyundai, Kia, we have all their suppliers, not just the plants. We have the Toyota in Huntsville, Mazda's got a plant, Mercedes got a plant. We have all their suppliers that make these little parts for these big cars. And you don't understand how the supply lines are affecting Alabama until I'm seeing our places are starting to hire second shifts.
Yeah.
Instead of they were working 6 days for 12 hours and they're like still not getting it done. So now they started hiring second shifts. So we've got 200, 300 more people all of a sudden on a payroll. And that's going to lead to injuries. You've got 200 new people coming in. No matter how good your training is, there's going to be an issue. So yeah, things are definitely coming back up.
Don't forget about Amazon seems to be building new distribution centers all over the state. I know right down from our office, they just opened up a brand new one in Irondale, and that's not 15 miles from another one in Bessemer. Mm-hmm. So those plants hire hundreds, if not thousands of people in each of their facilities. So
Walmart distribution has like 3 in the state. Home Depot has several.
Yeah.
We have a huge presence that people don't realize we have.
So I guess from a sense of, I hate to use the word normalcy, but from a sense of numbers, you're starting to see that rise or come back up. Is it anywhere close to the pre-pandemic numbers that you guys were seeing? And I kind of thought so, because we certainly are as well. And it really is a lot of it is from the manufacturing side of industries. And so from at least that perspective, those type of claims are continuing to go forward. Now, one of the things that the Alabama Supreme Court has done, and the Administrative Office of Courts, is they allowed all through the pandemic, they changed and made new administrative laws and rules and protocols so that we could continue to service this type of case. So we were able to continue having claims resolved. We did them and approved remotely through Zoom, through just various ways. So I'm very proud that the state bar was able to address those things, but it then still took adjustment on everybody's parts, like anything else has happened, but it still doesn't replace, and this is where the last part of our talk today is just how key, how crucial, and we keep coming back to it, is the communication aspect. And here's my example, Tracey, and this, I want you to share a little of your experience. You're having a conversation, let's say with plaintiff's counsel, and I'm not going to use my brother this time as the example, but he or she sees a particular issue that, and here's one that I'll use from one of our prior cases, not mine and yours, but one of our firms. It is protocol, for those who don't know, that when you get hurt on the job and the person goes to the emergency room or goes to the first professional to deal with them medically, they're typically, and if the company is subject to the work comp laws of Alabama, they're going to be drug screened. So that drug screen typically takes, I don't know if they have rapid tests now or 24, 48 hours. Well, let's say that, Tracey, it comes back and it's positive for some illegal substances. And this happens. It happens frequently, unfortunately. And your response in this scenario is, we're going to deny the claim because we don't know what all happened, other we know that the injured worker has some very significant injuries that they're claiming someone else caused. So
at the very least, I'm sorry.
I was going to say, pick up that scenario, because I want to talk through just a little bit about why communication aspect is so important about dealing with this type of particular case or situation.
I feel kind of put on the spot. So right off the bat, the statute calls for 3 different methods that deny compensation. It may not deny the entire claim, but it would
Right.
deny your compensation right off the bat. And that's a positive drug screen because that's the presumption of guilt.
Mhm.
So right off the bat, the compensation's kind of off the table.
And compensation, guys, she's talking about money, not medical benefits. This is being paid for not working right now, but go ahead.
So the medical benefits become a dispute.
Mhm.
So the very first thing I'm going to ask is there security footage? Because a lot of times if there's video, that takes care of all the questions.
That's
'Cause
right.
I can see it, especially if there's audio, but a lot of them don't have audio, but at least I can get a visual. The second thing I'm going to ask for is witness statements.
Mhm.
And then I'll probably look even at the levels. What drug was it and what level was it?
Mhm.
Is it a prescription drug that turned out he did have a prescription for? Then we're off, the whole thing's cleared up. Or if it's pot versus cocaine, there's
Mhm.
going to be some issues there because some court cases have kind of watered down
Mhm.
the cannabis and pot situations. And then we're going to see what that drug, what his levels were and how that contributed to the accident. In the past, I had one, he'd come into work, nobody had seen him. So nobody knew he was drunk because he worked in a lonely area basically.
Mhm.
He didn't clock in. We can only assume he was too drunk to remember. He didn't clock in. He just went back to his area and started working.
Oh.
There was a bad accident. And when they got to him, his alcohol level was more than 3 times the limit. You don't get a lot of room for dispute there. That was pretty evident. There was a lot of issues already going on.
Mhm.
So the presumption of his issue that the alcohol is what caused it
Mhm.
was pretty strong, but sometimes it's not as strong. But there needs to be some kind of proof that that is what caused the accident.
And it's during this investigation before decisions have been made by the insurance company. That could be 10 days, it could be 20 days, it could be 30 days, because there's so many moving parts here of information that they need. So it's during that 30-day window, I'll call it. And let's say that I'm representing this person where there's this dispute. My phone is getting blown up. Why am I not? What's going on? Why are they this and that? So our job, so that they're not blowing up Tracey's phone, is to explain about this process. Well, sometimes it doesn't matter what we say to them. We're not working fast enough and then they'll fire us. Well, we probably didn't want to keep that case anyway for that reason, but then they're going to now start blowing up Tracey's phone. So from a communication aspect, it is crucial between the insurance company and the attorney, plaintiff's attorney, the injured worker's attorney, that there's some communication flow right there. Because sometimes we'll get an email or a call. Hey, your guy is killing our phone system. He is burning it down. Please call him. Tell him to call you, not us. Because you call 10 times in one day, and that does happen. You're not going to get any work done if you got to keep answering the same phone call or dealing with the guy. That's rare, but it does happen.
Well, and then to just kind of throw this out there, when a client is represented, they're not supposed to have any contact with
That's
us
right.
anymore.
That's right.
Everything is supposed to go to the attorney because they've hired the attorney to handle that.
Yeah.
But yeah, the attorney didn't give them the answer they wanted, so they're going to call me and see if it's my fault.
Mhm.
Where's my mileage? Well, I have to be confirming something. Maybe I don't have the bills to confirm that mileage.
Yeah.
Where's my prescription? I don't have a script for you. I'm trying to find it. I'm trying to, and again, it comes back to that communication. It always comes back to communication.
Mhm.
And there's a lot of moving parts, just what you said. There's the attorney, there's the doctor, there's the client, there's maybe a case manager, there's the employer, there may be witnesses, there's me, there's maybe I had to send something to a defense attorney because I needed a legal opinion. Because if that drug case had happened, I'm going to have to send all those moving parts to somebody else because, again, I'm not a lawyer. I can't make that final denial decision. I have to send it either through a committee or through another defense attorney. And all of those are going to take time. And a lot of times, time gets to be a rare commodity.
Well, I was going to say my timetable is always going to be much quicker than your timetable. Well, I shouldn't say always, but for the most part, because my client is in need of X or Y or Z as part of the equation. So I guess in conclusion, while we don't always get along, we don't always see things eye to eye or see the way that the claim should unfold or play out. The only way that this works with any amount of success is there's this continued communication back and forth. Doesn't always have to be an agreement, but there does need to be that communication. And that's, guys, that's why I asked Tracey, who I've known for many years, to come on today to explain part of the process that even if you're an injured worker, you don't get to know that aspect of it. You just know that Tracey and others who do claims representing, they work for a big old insurance company in your mind or in the injured worker's mind, when in fact they're in state, they know Alabama law, they know how the Comp Act is supposed to work. But as a side note, Tracey, there's nothing more frustrating than getting a claims representative out of state who doesn't know how Alabama law works. And you end up, you, meaning me, end up either having to educate that person or getting them to tell you, well, who's your litigation counsel? So I can go to them, then they can go to you to communicate. But that's what we appreciate about what you do, being in state and as experienced as you guys are handling Alabama claims.
It works both ways. I'll get the random attorney that they're, especially in Alabama, we have a lot of small town attorneys. They are very, very versed in a lot of things, and they do a lot of different things, from divorces to car accidents to everything. But workers' comp is a different kind of animal.
It is.
And there are times we'll get an attorney that, I got this claim, I'm helping out a friend, or, and I'm like, that's not how workers' comp works. This is not personal injury. There's not pain and suffering. There's not, you can't send to multiple doctors. We're very precise. This is the steps.
We'll take this
and
to a jury.
It works both ways.
You know, of the, Tracey, of the 18,000 or so practicing lawyers in our state or admitted to the bar, I dare say there's less than 100 who practice work comp on the injured workers side with any regularity. But that's what you get.
Well, you say that as a joke, but literally yesterday I got one demanding a jury trial.
Nice.
For those that don't know, workers' comp has bench trials, which means we appear before the judge and not before a jury. And I think I know for a fact, in the nearly 20 years I've been doing this, less than 10 have ever gone in front of a judge bench trial. We might go for a walkthrough, which means we've already come to our agreement. We were showing the judge going, look, we did this. But very rarely have we ever gone to trial. That's because we all communicate. Most of us, not all of us. Well, Tracey,
okay.
Small percentage.
We'll save that for offline discussion. But Tracey, thank you so much for spending some time and just sharing a little bit of your perspective, because it's not one that we get to see very often. Sometimes it's one we take for granted, but we shouldn't. We know that you guys are just as busy as we are. You have just as many clients and people you got to deal with as we do. But thank you for taking some time talking about the importance of communication and how it can make both of our jobs hopefully just a little bit easier each day.
Well, I'm glad I could help. Thank you for inviting me.
Absolutely. Guys, that's why I do these conversations every week, 10 o'clock Central, Nomberg Law Live. It's interesting conversations with people in their areas of expertise, and Tracey Stallings certainly fits that bill. I hope you guys continue to be safe out there, do what's right for your family. Have a wonderful holiday season, and we'll catch you again next week.
Thank you.